are siblings, huh?
Yes, my lord.
Are siblings and are in a squabble on several.
First petitioner is the mother. Second petitioner is the brother of the respondent, second respondent. They are brothers.
And this is all family members.
member.
The first petitioner is the mother of the second petitioner and the complainant. Therefore, the second petitioner and the complainant are siblings. They have a squabble over certain issues, which has led the second respondent complainant before the concerned magistrate invoking section 200 of the CRPC. Second round.
Oh. Well, in the first round, the petitions would question the legality and correctness of registration of the crime and would seek for the quashing of the FIR. And this honorable court, having felt that the allegations made in the complaint warrant an investigation, let there be an investigation and this honorable court,
My order.
your lordship's order. And after the completion of the investigation, a final report in the form of a charge sheet is filed. And on the strength of that charge sheet, my lord, the court is said to have taken cognizance and ordered process against the petitioners. Now, may I request your lordships to kindly turn to ink page 552.
552.
552. That is the proceeding sheet. If this appeals to your lordship, probably I need not disturb your lordship on the merits of the matter.
Cognizance order.
Oh, well, in the latest judgment of the Supreme Court, what the Supreme Court has said is application of judicial mind for the purpose of 190 is totally different from application of judicial mind for the purpose of issuance of process under 204. That is how, my lord, in Vikas and in Vikas Court.
That's my respectful submission would be this is the order of cognizance which my lord is seeing at 552. Now, this is a case post investigation, charge sheet filed, and on that basis.
No problem.
Now, the difference, as my lord should repeatedly point out, if it is going to be a complaint under 200, while taking cognizance, the application of mind, disclosure of application of mind is more because my lord says no investigation.
204 is the only provision which permits issuance of process.
Out.
Expert says, no, it is not possible.
Anyway, we'll see that, my lord. So, on a
There-
question of fact, on merits,
My lord,
I will not
dirty
enter into merit.
charge sheet witnesses, 4 and 6
Not
times if
wait,
it's
wait,
going on the
wait.
merits of
It's an
it.
offense of forgery. When the matter is referred to an expert for examination and report, there should be two types of positive opinions. Number one, it is not the complainant signature or the writing. Number two, it is the signature or the writing of the accused. What should be in positive? Well, what he says is, it is not the signatures of the complainant, but he does not say that. Please,
He is brought back under 319?
I'm sorry, my lord.
He is brought back under 319, is it?
Well, more than anything else, my lord, the procedure that is adopted by the learned trial judge is unknown to law. I shall just give your lordship a few facts, my lord, in just 2 or 3 sentences. Well, the final report in the form of a charge sheet came to be filed against the petitioners complaining of the commission of an offence under section 302 IPC, among other offences. All of them are on bail. Well, the trial went on. Charges came to be framed. Petitioners pleaded not guilty. Trial went on. Nearly about 65 witnesses came to be examined. Then, my lord, the prosecution would close its case or side. Thereafter, the trial court would post a matter for recording of the statement of the accused under section 313. Statement of the accused also came to be recorded. Then it was set down for either for defense evidence or for hearing final arguments. It was at that point of time, my lord, a writ petition came to be filed before this honorable court seeking for further investigation at the hands of some other agency. But that writ petition came to be dismissed by this court. But the aggrieved would take up the matter before the Supreme Court in a special leave petition. That also came to be dismissed. In the meantime, they would also make an application before the benign government seeking for an order for further investigation. And what the government does is, in exercise of the powers said to have been closed upon under 173(8), though it is not so, it is only a power that is closed upon the investigator, not upon the state government. If my lord were to read section 173 subclause 8. However, my lord, the fact remains that the government would order for further investigation.
Government orders.
Government orders further investigation despite the dismissal of the writ petition and also the special leave petition by the Supreme Court. Doesn't matter. Well, further investigation came to be taken up. Additional
That's
report.
5 years ago.
Yeah.
Further investigation order is 2019.
Yes. My lord, the issue is this. Let them file, doesn't matter. I was agreed, my lord, subsequently I filed. Additional report came to be filed.
Hmm.
It can't be a supplementary charge sheet or a fresh charge sheet. ಐವೋ ಜೊತೆ ಬರ್ತಾರೆ ನಾ ತೋರಿಸ್ತೀನಿ ಅಂತಾನೆ. ಅವಾಗ ಐವೋ ಓಡೋಗ್ಬಿಡ್ತಾರೆ ಅದನ್ನ. ಅಲ್ಲಿ ಇರೋದೇ ಇಲ್ಲ. ಆಮೇಲೆ ಏನಾಗ್ತಾರೆ? ನೋ ಇದೆಲ್ಲ ಮಾಡಬಾರದು ತಪ್ಪು. ಎನಿವೆ ಐ ವಿಲ್ ಇಶ್ಯೂ ಎ ಬೇಲೆಬಲ್ ವಾರಂಟ್ ಅಗೇನ್ಸ್ಟ್ ಹಿಮ್ ಅಂತ. ವಿಟ್ನೆಸ್ ಅಲ್ಲೇ ಕೂತಿರ್ತಾನೆ. ಬೆಂಚ್ ಮೇಲೆ ಆಚೆ ಕಡೆ. ವಿಟ್ನೆಸ್ ಓಡ್ ಬರ್ತಾನೆ. ನನಗೆ ಯಾಕೆ ವಾರೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಿ? ನಾನು ಇಲ್ಲೇ ಇದ್ದೀನಿ. ಅಯ್ಯೋ ನಾನು ಹಿಡ್ಕೊಂಡು ಕೂತ್ಕೊಂಡಿದ್ದಾನೆ ಇಲ್ಲಿ ಕೋರ್ಟ್ ಒಳಗಡೆ ಹೋಗ್ಬೇಡ ಅಂತ ಅನ್ಬಿಟ್ಟು ಅಂತ. ಇದೆಲ್ಲ ಪ್ರಸನ್ನ ಕುಮಾರ್ ಗೊತ್ತಿಲ್ಲ ಇದು. ಸೊ ನಾವು ತಳ್ತಾ ಇದೀವ. ಅಲ್ಲ ಇವ್ರು ನನಗೆ ಅಪೋನೆಂಟ್ ಅಲ್ಲ.
ಅಲ್ಲ ಸೇಮ್ ಜೊತೆನಲ್ಲೇ ಇದೀವಿ. ಐ ಹೂ ಹ್ಯಾಸ್ ಫೈಲ್ಡ್ ದಟ್.
ಈ ಕಡೆ ಯಾಕೆ ನಿಂತಿದ್ದೀರಾ?
ಜಾಗ ಇರಲಿಲ್ಲ.
ನಾನು ಇಲ್ಲಿವರೆಗೂ opponent
He is my opponent.
ಇಲ್ಲ ಐ ಫೈಲ್ಡ್ ದಟ್ ಅಪ್ಲಿಕೇಶನ್ ಬಿಫೋರ್ ದಿ ಟ್ರಯಲ್.
So, Dali, legal issue which I have raised for my lord's consideration is, even for the purpose of passing an order of reference, just like issuance of process 204 or for the purpose of taking cognizance of 190, what is needed is a little application of judicial mind on the part of the magistrate.
All right.
No, but may I just request your lordship to kindly attend to the order that is passed by the magistrate. What he says is, there has been a compliance with the requirements of law as
Priyanka
mandated by the
Srivatsava.
Supreme Court under, in that Priyanka Srivatsava. Therefore, I am passing an order of reference. That is incorrect. May I request your lordship to kindly turn to, this is the first legal submission which I am making.
If that is a submission, we'll send it back. And what's the matter on that ground? Non-application of mind, I will right away send it back.
ಅಲ್ಲ, ಒಂದ್ಸರಿ ಓದ್ತೀನಿ ಇದನ್ನ.
ಏನೂ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ.
ಅಲ್ಲಲ್ಲ, ಯಾರಿಗೆ ರೆಫರ್ ಮಾಡಿದ್ರೆ ಆಫೀಸ್ಗೆ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್. ಅವ್ರ ಆಫೀಸ್ಗೆ
Office is direct.
Office is directed to register case and investigate.
The classic illustration of non-application of.
153, order 155-2. Otherwise, no.
We'll send,
Merely because there has been a compliance, he can't refer it.
we'll send it back. You can come back.
Leaving open, my lord.
Yes, all contents, right away. Yes.
Civil suit dismiss ಆಗೋಗಿದೆ ಅವರದು.
ಅದೆಲ್ಲ ನೋಡ್ಲಿ ಅಲ್ಲ. The petitioners ಅಲ್ಲ. The petitioners accused 1 and 2 are before this court calling in question an order of the learned magistrate dated 30th April 2024 by which he refers the matter for investigation under 156(3) of the CRPC. Heard the learned senior counsel Shri C.V. Nagesh appearing for the petitioner and senior counsel Shri Pramod Nair representing the second respondent complainant. The petitioners and the respondent complainant are siblings, huh?
Yes, madam.
Are siblings